discussed about this a bit several times, I believe, about sell and purchase. Just briefly. So sell and purchase is an agreement by which one party binds itself to give up the rights of goods and the other party to pay the promised price. Yeah. You can see in the chapter 5, 1457. Yeah. 1457 ICC. In the general provisions, jual beli adalah suatu perjanjian. Jual beli adalah perjanjian. Dengan mana pihak yang satu mengikatkan dirinya, binds itself, untuk menyerahkan suatu kebendaan, to deliver something, to deliver some property, dan pihak yang lain untuk membayar harga. So harga dan barang tuh. That is the essence of the sale and purchase. One party has to deliver the property or the goods, and the other party has to pay the purchase price. That. It's very simple, right? One has good or property, one has the money to pay. What is promised by one party, the seller, is to deliver or to transfer his right of ownership of the goods that he offers, while those promised by the other party is to pay the price he has agreed to. Same meaning lah. This is important. Sale and purchase is a consensual agreement which has been born as a valid agreement when the agreement is reached between the buyer and the seller regarding the basic elements, namely goods and prices, barang dan harga. This consensual nature is regulated under Article 1458. So the next clause, the next provision that we just read before. The agreement is deemed to have been made between the parties as soon as they reach consensus on the subject matter and the price, notwithstanding that the subject matter has not been delivered or that payment has not been made. Subject matter in here refers to kebendaan, Jual beli itu dianggap telah terjadi seketika setelahnya orang-orang ini mencapai sepakat tentang kebendaan tersebut dan harganya, meskipun kebendaan itu belum diserahkan. So we will continue, so to make you understand better. So the point in here, the point is 1458, is that the sale and purchase agreement under Indonesian law is an obligatoir concept, I think it's in the next slide, Okay, in here. It's an obligatoir concept, meaning that the law differentiates between when the agreement is considered as consummated, or when the agreement is entered, and the transfer of right. That's why we understand the phrase of legal delivery, atau levering, juridische levering. There has to be a delivery, there has to be a levering, there has to be penyerahan. So the one is an agreement, the second is the delivery. They differentiate that thing. That's why the 1458 says that. So even though the payment of the purchase price and the goods delivery is not made yet, the sale and purchase is considered as binding already, because it is considered as have been made before. So it is binding, and it is based on consensus or agreement between the parties. So what must be handed over by the seller to the buyer is the ownership of the goods, not just the possession over the goods. All that has to be done is submission or legal leverage. This is not the correct word, I think. Let me check. According to civil law, there are 3 types of judicial submission. This is not the correct word. Judicial delivery. Namely, delivery of moving goods, movable goods, movable goods, delivery of immovable goods, delivery of receivables, or we can say registered receivables, because they said they refer to atas nama, hutang atas nama, so it is registered under your name. Delivery of movable goods, immovable goods, delivery of registered receivable. So if you see that, those things, this is the delivery of title. So as again, I said before, there is a difference between delivery, between the obligatoir of the agreement is reached, but that doesn't mean that the transfer of title is done after the agreement is considered as be effective. So we have to see that there is an agreement, sale and purchase, but there is another event for delivery of title. That's 2 different things. Now, the delivery of title happens not because of the payment of money. Because as you can see in here, the number 1 and number 3, number 2 is different. The delivery of immovable goods, like you can see it here, it refers to our agrarian law. It is based on customary law, hukum adat. So it is no longer applicable for the land and building, actually, because the land and building and everything related to the land now refers to the agrarian law of 1960 and all the implementing regulations. And the mindset is different, the concept is different. But the number 1 and the number 3 are still applicable because they are talking about the movable goods, barang bergerak dan barang tidak bergerak, barang bergerak dan barang tidak bergerak. So they talk about movable goods, and the movable goods are still bound or are still regulated under the ICC that we have now. So 2 different events. One is the agreement, and then the second is the delivery of title event. Now, the next clause you can see 1459, you can see like this. Hak milik atas barang yang dijual tidaklah berpindah kepada si pembeli selama penyerahannya belum dilakukan. Menurut pasal 612, 613, dan 616. The 616 we don't discuss because it goes back to the immovable goods under the Dutch law. But we don't have it anymore, so we can just disregard it. But the 612 and 613 is relevant. So let's see. 612. Penyerahan kebendaan bergerak terkecuali yang tak bertubuh. Penyerahan kebendaan bergerak kecuali yang tak bertubuh, so meaning like movable but intangible, tidak bertubuh. Dilakukan dengan penyerahan yang nyata akan kebendaan itu oleh atau atas nama pemilik. So actual delivery. So you buy something, the transfer of title happens when you actually deliver that item, or on behalf of the owner. This is related to the proxy. Atau dengan penyerahan kunci-kunci dari bangunan. So imagine that you have a warehouse and there are contents in the warehouse, or you have a house, there are contents in the house, right? Furnitures, like chairs, tables, those are movable goods, right? But the deal is, when we enter into sale and purchase of property, the movable goods are also integrated as the purchase item. So that's why by giving the key of the house, it will be considered that all the furnitures are transferred to the buyer, ya. Dengan penyerahan kunci dari bangunan dalam mana kebendaan itu berada. Penyerahan tak perlu dilakukan apabila kebendaan yang harus diserahkan dengan alasan hal lain, ya, telah dikuasai oleh orang yang hendak menerimanya. So if the buyer already occupies it, already possesses it, yeah, you don't need to deliver anymore, yeah, because it's on your hand already. And then 613, ya, penyerahan akan piutang-piutang atas nama dan kebendaan tak bertubuh lain dilakukan dengan jalan membuat sebuah akta otentik, ya, atau di bawah tangan. So you either have to make a deed before the notary, ya, or you can just do a privately drawn deed, dengan mana hak-hak atas kebendaan itu dilimpahkan kepada orang lain. And then the other thing, penyerahan yang demikian, so that delivery, yeah. So the first paragraph says the delivery, you know, since it is intangible, you cannot see it, right? You cannot see the right, it is intangible, makanya disebut tak bertubuh. So how can we deliver it then? Yeah, that's the main question, right? If you deliver a table, it's very clear, right? You can see the table. But if you deliver that I have receivable against someone, how do you see that receivable? It's not tangible, yeah. Nobody can see it. It may be written in the contract, it may be admitted by the debtor, but again, the receivable is intangible. You cannot see it. So that's why the law makes a certain procedure or a special procedure in order to deliver, to legally deliver that right, that intangible right. What you can do is you can do SSC. Yeah, this is called SSC. So the delivery of right. Yeah, I transfer my right, and then I deliver it to you. Yeah, because when I just agree to sell my right, that's a sell and purchase agreement. That's one event. Yeah, but how to deliver it legally? Yeah, to deliver it legally is to make a deed, yeah, whether it is an authentic or whether it is a privately drawn deed, to make a deed and then you deliver it to the other party. So it's clear then there are two events. One is the sell and purchase agreement of the right of receivable, and the second is the delivery of the right of receivable itself through that authentic deed or privately drawn deed. Now, the second paragraph of 613, penyerahan tiap-tiap piutang karena surat bawah dilakukan dengan penyerahan surat itu. Oke. Penyerahan tiap-tiap piutang karena surat. No, not that. Penyerahan yang demikian bagi si berutang tiada akibatnya, melainkan setelah penyerahan itu diberitahukan kepadanya atau secara tertulis disetujui dan diakuinya. So you have to notify the debtor in order to validate that delivery. Well, I think the reason is simple, because if there is a change, a replacement of creditor, of course the debtor should know about it, yeah, because the debtor is required under the law to pay the money to the creditor, right? If the creditor is replaced, is changed, and the debtor is not aware of it, of course the debtor will pay the money to the old one, right? So it must be notified to the debtor. Once it is notified, it validates delivery, yeah, and then of course the debtor will have to pay the money, the loan, to the new creditor as notified. So it is not very many anymore. I think, yeah, maybe still in the transaction of sale and purchase of shares in the company, it normally will lead to sale and purchase of receivable also, yeah, normally, but not all the time. Sometimes they take they use the novation concept, sometimes they use the subrogation concept, so it can take several other things. But when the monetary crisis in Indonesia in 1998, 1999, yeah, there were so many banks, there were so many companies defaulting in their payment. So the bank carries so much bad debts, yeah, because the debts that you cannot collect, yeah. So the banks carry all of the bad debts, but under the regulation they cannot do it, yeah. They have to reduce the bad debt ratio, and the way the banks reducing those bad debt ratio is by selling it out, by selling the bad debts, yeah. And then there are private parties or a businessman that would like to take it over, yeah, take over the bad debt, and then they will try to collect the money from the debtors. That what is done actually, and there are several companies are doing it, yeah, and until now. So there is a difference, yeah, between subrogation and novation. Yeah, when it is a subrogation, if the debt is 100, then you replace the position of the creditor. It cannot be less than 100. Yeah, but if it is a sale and purchase through sesi delivery, you have a debt, you have a receivable for 1,000, for example. Yeah, someone is owing you 1,000 rupiah, for example. Yeah, but he doesn't pay back, right? He doesn't repay his debt to you, so you carry a bad debt, and then you just sell the bad debt to the other party. Well, the other party will negotiate, of course, right? He wants to get the 1,000 receivable, right? But since the debtor is in default, so it is most probably that the debtor will not prepay him anyway. Yeah. So he will negotiate down the price. So 1,000 is for normal situation, right? But since the debtor is in default, most probably he will not repay the money. I can only pay for 100, for example. So the 1,000 receivable right is sold for 100. Yeah, that's a sale and purchase of receivable, and that is allowed, right? Because as long as the party agrees to it, that's fine. The 1,000 receivable is sold for 100 rupiah, for example. And then what happens next after the purchase is done and the sesi is made, right? So there is a sale and purchase agreement and there is a sesi deed, okay? After those are made, of course, the new creditor now has the right to collect 1,000. And remember, he only bought for 100, this 1,000. So if he is good in collection, he can get the capital gain, yeah, for the rest of 900. And in the monetary crisis situation, 1998, 1999, there are lots of transactions like that in Indonesia. But I'm not sure that it is still the same everywhere now. Okay, we talk about this, yeah. We just talk about this. About the 1459. The ownership right over the asset sold do not transfer to the buyer until after delivery takes place, in accordance with the provisions of Article 612, 613, and 616. Yeah, we just talk about this. So there are still many things, yeah, we can see and we can talk about. But of course, we cannot talk about anything. But the sale and purchase provisions are not so many. So I encourage you to read it. Yeah. So you have the sense of more understanding about this. And then we jump to 1471. Jual beli barang orang lain adalah batal dan dapat memberikan dasar untuk penggantian biaya, kerugian, dan bunga jika si pembeli tidak telah mengetahui bahwa barang itu kepunyaan orang lain. The sale and purchase of another person's asset is void and may provide grounds for the buyer to claim for compensation of costs, damages, and interest if the buyer was unaware that the assets were owned by somebody else. Now this provision is appearing awkward, yeah, or odd, because as I just explained that the sale and purchase concept is obligatoir. So it means that the agreement is entered even though the delivery has not been made, and the agreement is considered as a valid agreement. So of course, because of that, one part A can sell to B without transferring the title yet, right? And then B, based on the agreement with A, B will try to sell the same thing to C. Yeah, even though the delivery has not been made yet, because the agreement is there already. So meaning, if there is an agreement, there is an obligation, right? Yeah, we understand, right, from the what we have discussed before, freedom of contract principle, pacta sunt servanda. So when the agreement is reached, the obligations arising, right? It creates an obligation between the parties. So the obligation of the seller is to deliver the item or the goods, and the obligation of the buyer is to pay the purchase price, right? That arising because of the agreement is made. So since the sale and purchase, you don't need to have a delivery of title immediately. So of course A can sell to B, can sign an agreement to B to sell, right? And then B can sell to C. Yeah. So B is still not the owner, of course. So that's why the 1471 is a bit odd, because it says that the sale and purchase of another person's asset is void. B doesn't have the asset yet, right? B just have an agreement. So that's why in the legal doctrine, this void is interpreted as voidable, not null and void. Oh yeah, if you look, just moving back a bit to the obligatoir concept of an agreement, yeah. In the book of Subjekti, you can see that the Supreme Court agrees to the obligatoir concept, yeah, in the sale and purchase agreement. So in my book in here is page 80. Prof. Subjekti quotes the consideration of the Supreme Court, yeah, that cancels the arguments by the District Court and the High Court, ya, bahwa dengan penyetoran uang harga pabrik tersebut, dengan sendirinya pabrik sudah menjadi milik tergugat yang menyetor. Dan juga penyerahan tidak mungkin dilaksanakan karena pabrik tidak lagi berada di tangan PT Dining. So the lower court, District Court and the High Court consider that if you pay the purchase price, the factory is becoming yours. it's done. Yeah. But it is not like that, yeah, by the Supreme Court. That's why the Supreme Court invalidates. So it will show that the Supreme Court is recognizing the concept of obligatoir. And the cases that I will give to you today is also related to that. Yeah, you can see it later on. Yeah, the judge must find an acceptable interpretation so that the article can still be used. Yeah. So that's about the 1471. Yeah. Thus, Article 1471 shall be interpreted that the sale and purchase of another person's good may be cancelled at the request of the buyer and may provide a basis for indemnity if the buyer does not know that the item belongs to someone else. Yeah. Well, if the buyer is not aware and the B is not disclosing the situation, yeah, that can happen. If the buyer already knows that the goods sold to him are not yet in the hands of the seller, then of course, yeah, he cannot ask for cancellation. Kan di sini dibilang jika si pembeli tidak telah mengetahui, ya kan? Jadi dia tidak telah mengetahui. Jika dia mengetahui, ya 1471 tidak berlaku. The price must be set by both parties. However, it is also permissible to submit the purchase price to the estimate of the third party. Okay, this is the third point is no longer related to the first, second points. Yeah. If you agree with someone else, the purchase price, it's agreed between you. Yeah. So actually, there is no interference on that, right? Maybe in some basic things, yeah, then the government interferes, yeah, or like what we experience in this pandemic situation, the government sets the price of PCR, yeah, the price of antigen and everything. That's for the public good, right? Oh, and that's for the people's good. So that's why the government has to interfere. But in other transactions, the government does not interfere, right? It is up to the parties. Yeah. So the property, for example, the true value or the intrinsic value of the property, perhaps 1,000, right? But the parties can agree to sell it for 1,500, right? Or can even sell it for 500 only, half of the true value of the property. So that's why the price is set by the parties. Yeah. And then 1465, and I think what is interesting is, yeah, 1465 says harga beli harus ditetapkan oleh kedua belah pihak. Harga beli namun dapat diserahkan kepada perkiraan seorang pihak ketiga. This is the appraiser, yeah, independent appraiser. So that is a third party. So let's say that I agree to buy this, but I don't know how much. Yeah, the seller doesn't know how much, the buyer doesn't know how much, or maybe they know but they want to just do the true value of the property, for example. Yeah, this happens in the land procurement law, undang-undang pengadaan tanah, where the appraiser will value the true value of the land that is going to be released to the state, and then the state will use it for developments for public interest. So that's the appraised value, ya. Jika pihak ketiga ini tidak suka atau tidak mampu ya, atau tidak mampu membuat perkiraan tersebut, maka tidaklah terjadi suatu pembelian. Ya, well, you can change the appraiser, right? Yeah, you don't need just to cancel the purchase. You find another one, ask them to reappraise this, and then proceed with the sale and purchase. Yeah, but perhaps if there is no one in the world that can value this property properly, then it might be, of course, that the sell and purchase is void. Yeah. Like a painting, for example, or like fine art things, yeah, other fine art items that is very exquisite, and it's very hard to value it. Yeah, maybe it sometimes happens like that. Yeah. So even there is no valuer for that. Yeah. There is no certified valuer for that. Yeah. So how do you appraise that price then? Thus, the sale and purchase set by a third party is an agreement with a postponed condition, syarat tanggung. Yeah, of course, yeah. You cannot proceed with the sale and purchase unless the price is set. And that is an essential items kan. That's the purchase price and the sold goods. So there is a good and there is a price. It's two components that are very essential for the sale and purchase. If one is not there, so how can you proceed with it? It is also permissible to set that price later, as long as the way it is set is approved by both parties. What is also interesting in here is the 1464. Jika pembelian dibuat dengan memberi uang panjar, like a down payment ya, or like a booking fee, tak dapatlah salah satu pihak meniadakan pembelian itu dengan menyuruh memiliki atau mengembalikan uang panjarnya. Ya, I think it happens everywhere, right? Okay, I just paid a down payment and then I changed my mind. I don't want to proceed with the sale and purchase, so you just can take my down payment and I cancel the agreement. Ya. Tapi di sini kan dibilang tak dapatlah salah satu pihak meniadakan pembelian. So the seller cannot do it, the buyer cannot do it. Ya. Dengan menyuruh memiliki atau mengembalikan uang panjar. So it would mean that if there is a down payment, then the sale and purchase is considered as being made. It is done already. Because the sale and purchase agreement is not about the payment, right? When there is an agreement of the goods and the price, then the sale and purchase is happening. So the down payment is only part of the purchase price payment, right? It's only a small part of it. But when it is done, even though you have paid or even though you have not paid, it doesn't mean that when you have paid, in this case, you have paid down payment, right? And then you just can cancel. No, you cannot cancel it anymore because you give the down payment or you don't give the down payment, the agreement is already in place, right? So it's binding to the parties. And then we talk about risk. 2 weeks ago we talked about this. Risk is the obligation to bear the loss caused by an event beyond the fault of the parties. If the asset sold consists of determined goods, it falls under the liability of the buyer from the time of purchase, notwithstanding that delivery has not yet taken place, and the seller is entitled to demand the purchase price. We talk about this, yeah. It is not appropriate to have it in the burden of the buyer, and that's why even the Supreme Court issued a circular letter saying that this clause is not applicable anymore. Yeah, and you study of course also. The district court judges did not really refer to the Supreme Court, yeah, but they mentioned this clause, but they mentioned another clause also, and that is what they use. So the 1460 is no longer applicable, yeah, and even though it is applicable, we understand from Pak Subekti almarhum that the goods must be very definitive, yeah. it cannot be just a general goods. Yeah, it must be very, very specific. If this kind of risk should be borne by the buyer, yeah, and that good must be destroyed, so completely gone. So in the fourth point, you can see this article is limited in effect only regarding certain goods that are destroyed before being handed over to the buyer. And of course, the risk involved the force majeure, right? Because the risk happens because of something that is out of control by one of the parties, and in this regard is the seller, right? A particular item means an item that has been designated and determined by both parties. Okay, but there are other things. Yeah, if the goods are sold not according to piles, but according to weight, quantity, and size, then the responsibility of the goods remain to the seller until they are weighed, counted, or measured. It means if the sale and purchase of goods is agreed according to weight, quantity, and size, and the goods have been weighed, counted, or measured, then the responsibility is transferred to the buyer. Well, what I remember also, the circular letter, I think, says that even though the Supreme Court says that it is not applicable anymore, but they also mention that it should be seen case by case, and it should be considered as proportional risk. Yeah, so it cannot be borne 100% by the buyer, but it should be seen also whether the seller has some obligations or has some interest, yeah, to also bear that risk. Yeah, so case by case, and also see that it should be more balanced. So 1461 and then 1462, if the goods sold according to piles, then the goods become the responsibility of the buyer, even though the goods have not been weighed, counted, or measured. And according to this article, the risk is charged on to the buyer from the beginning. So it can be concluded that the risk is borne by the owner of the goods, namely the seller, or at least based on agreement of the parties. Yeah, I think if there is confusion about this, that there is a risk that one should bear, right? And the law seems confusing about this or seems unfair, I think it is good that let's just agree. Yeah, if this risk happens, who bears the risk? Yeah, if that risk happens, who bears the risk? So we just make an agreement about risk. Yeah, I think it's better that way than just debating about interpretation of the Indonesian Civil Code. So in addition to deliver the goods, the seller is also obliged to guarantee it. Okay, but before that, I remember that. Okay, you have to go to 1473, 73, and 1474. Ya. 1473 si penjual diwajibkan menyatakan dengan tegas untuk apa ia mengikatkan dirinya. Segala janji yang tidak terang dan dapat diberikan berbagai pengertian harus ditafsirkan untuk kerugiannya. This is important principle, ya. So the seller must be very clear what he is selling, yeah, and what he is bound to do. Yeah. Every promises that is considered not clear will be your losses actually, ya. Jadi untuk kerugiannya kan harus ditafsirkan untuk kerugiannya. And then 1474, ia mempunyai dua kewajiban utama, yaitu menyerahkan barang dan menanggungnya. So we talk about delivery all the time, ya. but it's not enough. Yeah, if you sell something, yeah, you are obliged to deliver it, yes, but it's not enough. Yeah, it's not after you deliver it and you just let it go. Yeah, no, you have to guarantee that the goods is okay. If you look into the international convention, international treaty, or some sort of like Incoterms, yeah, they will regulate that the goods sold should be fit to use as its purpose. Yeah. So, but this is only happening and only applicable for the business, for the transaction like this, for the business and commercial transaction. If you are just selling, not as a businessman, I mean, maybe you have used laptop and then you just sell it out. Well, you should not be responsible whether this laptop is usable or not, because the defect is something else. Yeah, but if you are a businessman, you are a distributor, for example, you are a distributor and then you are selling goods to the public, then of course you have to be responsible. So ensuring the possession of goods sold safely and peacefully. Yeah, so it is your item. It is not someone else's item. So if you sell something, you have to make sure that you have the right for it, right? This means that the seller is obliged to guarantee the buyer against any penalty for handing over all or part of the goods sold to a third party, or against the charges that, according to a third-party statement, he owns those charges, and that fact is not verified when the sale is done. So, memang, of course, the buyer should inspect, right? The buyer is obliged to check about the goods, yeah, whether it is fine, it is okay or not. Now, everything, if you buy through online mobile apps, right? Everything the buyer do is just rely to the seller's information, right? If the seller says that there is a defect in here, and then he gives the picture, so it's clear, yeah. So we rely on the information by the seller. But how can we inspect the goods anymore, right? We can only inspect after we receive it. So after the purchase is made, the delivery is done, we receive the goods that we bought, then we can inspect it. Yeah, it's a very different than what is regulated under the ICC, actually, because there is a hidden defect, there is a apa itu ya, known defect, yeah. But to know whether there is a defect or not, well, you have to inspect the thing, right? This is problematic. I think this is interesting, to do research on this, or to make a scriptsy out of it, yeah, to make a thesis about this. I think it's very interesting, because the buyer is also has the obligation to inspect, yeah, because buyer must do some due diligence. If the buyer understands that the good is problematic, the buyer may not be considered as a good faith buyer, actually. That's what happens with the mafia. The buyer of the land, the buyer of the things that is being sold several times, and included in the mafia circle, they know that this is a problematic thing. So, but they transfer it anyway, right? A transfers to B, B transfers to C, to make it appear that the transactions is legit, yeah. But it is not, yeah, because if you are aware that the good that you want to buy is problematic, of course you will back down. or you may think about it first. Yeah, you just don't immediately buy the thing. If you are aware that that there is a problem, but you still buy it, you might not be protected under the law. That's what happens in the land regulation, actually, land cases. I mean, where there are so many um, defective land being sold to the third party. Yeah, but this third party is an honest party. Yeah, it can happen to you or me. Someone says that he's the owner of the land, and then he tries to sell it to me, for example. I have checked, I have submitted the sale and purchase to the PPAT, right? The PPAT has checked to the land office. Everything looks good. The land office says the certificate is there. I mean, the certificate data and the land book data are the same. And then we proceed with the sale and purchase deed before the PPAT. I have done my part according to the law. So that is considered as good faith buyer. And as good faith buyer, you are protected under the law. So what the judges say, okay, the true owner of the land is claiming the previous seller, right? Because the previous seller is not the true owner, but also claiming me as the buyer. But the judge says this one, Eddy, is the good faith buyer. So the land is still owned by Eddy, yeah, because he bought everything properly, he followed the procedure and everything. This is under him. So what you can do is you file a claim only to the seller who is selling the good to Eddy, because that seller is not a good faith seller, right? So you file a claim to that seller, not to Eddy. What happens, and it becomes more and more as a good jurisprudence, yeah, for Indonesian law, especially land law, because that creates some sort of certainty now. Because without it, there is no legal certainty for the land transactions in here. So ensuring that there are no hidden defects. Well, if it is hidden, maybe the seller is not aware of it also, right? But if he or she is aware, of course, he has to be responsible for it. Yeah, there is no arguments for it, and it is very clear that if he is aware of the hidden defect and he's still selling it out, of course, it is a bad faith seller, a dishonest seller, right? In contract law, as a complementary law, both parties are allowed with special promises to expand or reduce the obligations stipulated by law. And even they may enter into agreement that the seller will not be obliged to guarantee anything. Yeah, I experienced this once. However, the seller was a Singapore company, and the seller was like a Singapore investment manager company. So no, not really investment manager. It's like a trust fund in Singapore. So they invest property in Indonesia. They cannot construct it because due to the crisis of monetary 1998. So they stopped the construction, and then they sell it to my company at the time. And then they don't want any risk coming back to them, so they cannot guarantee anything. You just need to inspect. If you are fine with it, you buy. If you're not, then walk away. Yeah, we cannot guarantee anything. So that is interesting. So although it has been promised that the seller will not guarantee anything, he is still responsible about the consequence of something he has done. Any agreement contrary to this is void. Well, you can agree anything, right? That's a freedom of contract principle. You can have agreement about a lot of things as long as it is not against the law, right? But of course, in this A, he is responsible about the consequence of what you do. Well, if you hit someone, there must be a damage made because of your blow. Yeah, for example. So if you agree that you will not guarantee anything, but you hit someone else, of course you have to be responsible for the consequence. Yeah, that's what it means in A. But if we agree that you will not guarantee anything, and then there is no blow to someone else, of course there is no consequence because you don't do anything, right? So this is just a protection, I think, for the other party. If we agree that someone will not guarantee anything, it doesn't mean that you can do anything that you want. Yeah, you cannot. If you do anything that you want and it creates damages, losses to the other party, of course you have to be responsible for it, even though we agree that there is no responsibility at all. The seller, in the event of the same promise, in the event of a punishment against the buyer for handing over his goods to other party, is obliged to return the purchase price unless the buyer at the time of purchase already knows. Nah, this is the interesting one. If the goods is owned by someone else and you have to return it, you have to refund the purchase price. The seller will have to refund. But you don't have to do it if the buyer already knows at the time of purchase that punishment to deliver that bought good, or if he has purchased that good with a firm statement that he will bear its profits and losses. So he just takes the responsibilities for the buyer himself. Yeah, he is aware of the situation and he takes it out for himself. If there is a punishment for handing over the goods he has purchased to someone else, then the buyer has the right to demand back from the seller. Now, this is the situation when the buyer is not aware of it. Yeah, refund of purchase price, return of yield, if he is obliged to submit those yield to the real owner who did the claim. So there is the seller, the buyer, and the true owner. Yeah, this is a three-party relationship actually. Costs incurred related to the buyer's lawsuit to be borne, as well as those that have been incurred by the original plaintiff. Compensation of cost, loss, and interest, ya, biaya rugi bunga, ya, is always there, as well as dispute cost. Nah, this is special one, as well as dispute cost, biaya berperkara, on the purchase and delivery, untuk pembelian dan penyerahan, to the extent they have been paid by the buyer. Now, again, the contract law is different than the unlawful act, perbuatan melawan hukum. The compensation under the contract law is limited to the cost, interest, and loss. Ya, biaya rugi bunga. Those are the categories. So you cannot just claim without able to prove that you have spent those monies, yeah, except for the interest, of course, yeah. And I think in some way for loss, well, it's a combination of something that you have spent and something that you consider as losses even though you haven't spent it. Yeah, so those are the things that is included in there. So the seller is obliged to guarantee the hidden defects in the goods that he sells that make the item unusable for the intended purpose, or that reduces its use, so that if the buyer knows the defects, he will not buy the item at all, or will not buy it other than cheaper price. So don't forget, yeah, the seller's obligation is also to guarantee the thing that he's selling, not only to deliver. So you can see that 1491 ya, penanggungan yang menjadi kewajiban si penjual terhadap si pembeli adalah untuk menjamin dua hal, yaitu pertama, penguasaan benda yang dijual secara aman dan tentram. Kedua, terhadap adanya cacat-cacat barang yang tersembunyi atau yang sedemikian rupa hingga menerbitkan alasan untuk pembatalan pembeliannya. And then there is a involvement with the third party claimant. 1494, meskipun telah diperjanjikan bahwa si penjual tidak akan menanggung suatu apapun, namun ia tetap bertanggung jawab tentang apa yang berupa akibat dari suatu perbuatan yang dilakukan olehnya. Ya, if we do something, it's like a cause and effect law, kan? If we do something, there must be an effect, right? So you, of course, when you do something, you have to be responsible for that effect. Segala perjanjian yang bertentangan dengan ini adalah batal. Yeah. So even though you agree to it anyway, that you will not be responsible for anything, it is considered as void. Okay, that's the hidden defect. Yeah. So 1504, yeah, the hidden defect clause is not so many. So you can see in the 1504, si penjual diwajibkan menanggung terhadap cacat tersembunyi pada barang yang dijual, yang membuat barang itu tak sanggup untuk pemakaian dimaksud, atau yang demikian mengurangi pemakaian itu, sehingga seandainya si pembeli mengetahui cacat itu, ia sama sekali tidak akan membeli barangnya, atau tidak akan membelinya selain dengan harga yang kurang. Of course, if we want to buy something, but we cannot use it properly, it's waste of money, right? It's useless. We better just return it and refund the money. Well, that can happen in every item actually. And the hidden defect, you cannot see it because it is integrated in the product, yeah. So there is a defect in the product. That's the hidden defect actually. When you look the product seems fine. Nothing is wrong with that. Yeah. But you cannot use it properly. Yeah. So there is a defect that you cannot see. That is hidden inside it. Well, it's not very easy to explain, but I have a case before about the hidden defect. It is very interesting. So I represented a contractor, yeah, and then the claimant was a oil and gas company. So oil and gas company claiming the contractor that I represented. Why they claim the contractor? Because the contractor, my client, sold goods to this oil and gas company. But they are not the manufacturer. They are just a seller. They are just the vendor. Yeah, selling these goods. They know the manufacturing company. So they went to the manufacturing company and then they saw the production and everything. Everything has been tested properly. Yeah. And there is also witnesses from the oil and gas company. Yeah. So everything sees everything. Yeah, everyone sees everything. The process has been seen, has been inspected. The certification was issued already according to the specifications that the claimant requested. Yeah. So the product is okay. Everything looks good. It is delivered to the oil and gas company, right? But the seller's obligation is just to deliver. So just to find the manufacturing company and then deliver these goods to the oil and gas company. That's it. Now what happens? After the goods are delivered, yeah, after the goods are delivered, this oil and gas company installs those goods in their facility. Yeah, I don't really remember anymore what is the use of that good. Yeah, but there are perhaps 20 to 30 specific goods, yeah, that they bought, that they have to install in their facility. And what happens when they installed it? There is a crack in the goods. Yeah, there is a crack. Maybe it happens to one of them or two of them. Yeah, there is a crack, and they realize that because of this crack, you cannot use these goods anymore because it will be too dangerous to their facility. Well, remember, this is an oil and gas facility, so everything must be perfect. Yeah, everything must run smooth without any problems. So they said this cannot be done. This cannot be used. This is not usable. Yeah, because I cannot run my facility when after I installed it there are cracks in some of the goods. So it will be very dangerous to run the facility with this. So you should replace it to me. Yeah, so that is actually what the oil and gas asking. You give me the replacement because this is surely not according to the specifications. Well, it's confusing now. Yeah, if we are, like I said before, there is a certificate already. They saw everything. They witness everything. Yeah, but still, so there must be a defect in the manufacturing facility then, or the manufacturing facility doesn't really issue the proper certificate. So there is a claim in the arbitration. Fortunately, it was settled. Yeah, so the contractor admits that there is a problem with their goods. Well, it's not their goods; it's the manufacturing company good. Actually, they are just a seller. But what happens in the case is the claimant, to prove that there is a hidden defect, what did he do actually? What he did is send this good to the lab. At that time it was, so they sent to the lab of ITB, yeah, ask them to inspect, and then they produces a report, yeah, showing that the specification of this item is different than the specification that was requested from the beginning by the oil and gas company. So it's very clear legally speaking, and it's very clear technically speaking, yeah, that there is a defect in the goods. Yeah, well, it's not very easy, right? A lawyer may not be able to say whether there is a defect or not, right? We are not a technical guy. There should be engineers, there should be scientists saying that, right? We are not that guy. That's why in the hidden defect like this, there should be an expert involved to determine whether there is a hidden defect or not. Well, it's very rare, you know, it's very rare cases about this, but it happens, you know, it happens, it just happens. You buy something that you cannot use it properly, but there is no known defect, you know, the thing seems fine, looks fine, but there is something wrong inside, and we don't know because we cannot see. But if we see and we know, but we buy it anyway, then the seller is not guaranteeing it anymore. Yeah? It's your problem, yeah. So you, as the buyer, you want to buy something, you see it, or in the mobile apps, the seller has disclosed that this is defective, that part is defective, right? Or you buy used item, right? Kalau barang bekas kan pasti ada rusak sana sini. You are fine with it. Well, there is no hidden defect. It is not hidden defect. It is known defect. You saw it. You are okay with it. Then it is It is not a problem of the seller anymore. Yeah. So you see, the hidden defect is not easy. You have to prove it properly, and you have to involve an expert. Okay, this is related to the movable goods, right? Also, the same can apply in the immovable goods. Well, land, I don't know, land, whether there is a hidden defect in land. Yeah, perhaps if there is a apa itu contamination deep inside the land, who will know that? Nobody will know. I don't know whether there is a technology to check. So before I buy the land, I will check this, whether there is a contamination or not. I don't know. Nobody is checking that, I think. But there is something like a hidden defect, yeah. But it is not really recognized in land, and I have never seen any hidden defect over land. Yeah, maybe it won't happen. But for building is something else, yeah, because building, when you construct building, there might be a problem, yeah, that you cannot see. Everything seems okay, but there might be a problem afterwards. Yeah, the collapse of pernah, ya, untung nggak ada yang meninggal waktu itu ya, tapi kan collapse tuh. When I work in that building, I pass that bridge many times, almost every day. Yeah, I was lucky that I was okay until now. It happens 10 years afterward. Yeah, it looks fine, but there is a problem. Yeah, so cacat tersembunyi concept is also applicable in building. Yeah, but they don't call it as hidden defect. Yeah, they call it kegagalan bangunan, but the same concept actually. Kegagalan bangunan if it happens when the building cannot be used properly as it is intended at the beginning, and it can be partially or fully or wholly. Yeah, kegagalan bangunan. So who has to be responsible? Well, I think the main party will be the contractor, of course, because the contractor who is constructing the building. But of course, it can be because of the design or because of the supervisor of the construction, or they can be blamed. All of them can be blamed. Yeah. So who has to decide whether there is a kegagalan bangunan or not? Building failure, yeah, we call it. Yeah. That is the expert assessor. Again, that it should be an expert to determine it, because if it is hidden, then it can only be a base on an expert determination, checking in the lab, right, just to make sure that there is really a hidden defect. It's very interesting. And the consequence now. Let's see about the consequence. But before that, let's look on the third point. The seller is obliged to guarantee, even though he himself does not know the existence of those defects, unless he has requested that he is not obliged to guarantee anything, of course. Same goes back to what we have discussed before. Under these circumstances, the buyer can choose. Yeah, when the buyer finds that there is a hidden defect, the buyer can choose whether he will return the item and demand the return of his purchase price, or whether he will still own the item while demanding a partial return of the price, as will be determined by the judge after hearing experts on this matter. So in my case, the experts is right, and then they file a claim to arbitration. What they demanded were to refund. So they just demanded the refund of the purchase price plus interest. Yeah, because when they claim through an arbitration, they have the right to charge 6%. If the seller has known about the defect in the goods, then in addition to being required to return, it is also required to compensate costs, loss, and interest. Well, it will be very, very tough, right, to prove that the seller knows it. has known about it or should have known it, that there is a hidden defect from the beginning, it is very hard, I think, because the buyer has to prove. The seller will not admit it, right? The seller will decline. So in my case, the buyer cannot prove that the seller knows or should have known from the beginning, because like I said, the seller bought that item from the manufacturing company. So the seller doesn't know actually that there was a hidden defect. Okay? But of course, if the buyer can prove that there is a hidden defect that should have been known from the beginning, of course they will file a compensation for cost, interest, and expenses. So the matter of the seller knowing this existence defects must be proven. If the seller does not know the defect of the goods, then the seller is only required to return the purchase price and reimburse the cost to do the purchase and delivery to the extent that it has been paid by the buyer. Okay, so other costs is fine, related to the delivery and purchase. Okay, so we see the sale and purchase in general. We see the obligation by the seller to guarantee the hidden defect and also to the safe possession of the goods. Now the obligations by the buyer. The buyer's main obligation is to pay the purchase price. Yeah, it's very obvious. At the time and place as stipulated. If the agreement is not specified about the time and place, then the buyer must pay at the place and at the time at which the delivery must be done. Ini kan COD ya, cash on delivery ini ya. Barang diantar kita harus bayar. For buyers, although not explicitly agreed, it is required to pay interest from the purchase price if the goods sold and handed over give yields or other income. Well, this is something like a machine, for example, yeah, that you can use for production and everything. If the buyer, while possess the goods he purchased, is disturbed by a mortgage-based lawsuit or a claim to reclaim his goods, or if the buyer has reason to worry about something that will disturb him, then he may suspend the payment until the seller has stopped that disturbance, unless the seller chooses to provide a guarantee, or if it has been promised, the buyer is obliged to pay without any guarantee over all disturbances. Well, of course, if there are problems, there is a claim, you can suspend, you can withhold, or you can hold your payment of money. That is legally allowed, yeah. Unless the seller says and guarantees that everything will be taken care of, blah, 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 right? Or if the buyer is aware of it from the beginning and the buyer is fine with that, yeah, that's another thing. If the buyer does not pay the purchase price, it is a default that provides a reason for the seller to demand compensation or cancellation of the purchase under the provisions of Article 1266 and Article 1267 of the ICC. So 1266 relates to the obligation that you have to go to the court, right, to cancel the agreement. But 1267, pihak terhadap siapa perikatan tidak dipenuhi dapat memilih apakah ia, jika hal itu masih dilakukan, memaksa pihak yang lain untuk memenuhi perjanjian, ya, atau ia akan menuntut pembatalan disertai penggantian biaya, rugi, dan bunga. That is the thing of obligation by the buyer. Now we are moving to the buyback. Hak membeli kembali. Well, this is not something that I experienced. Yeah, actually, I've never experienced this in my dealing in a sale and purchase transaction. Yeah. And you can see in the jurisprudences of land law, the buyback principle is not recognized. Yeah? So there are so many buyback in the land was not recognized by the court. So it is considered as null and void. Yeah, so many jurisprudences, I think more than 5 already. I've seen it. Yeah. So this buyback clause is only applicable, of course, for the movable goods, not immovable goods. Yeah. So we're not talking about land in here. Yeah. And even though the buyback principle is in the ICC and the ICC covers movable and immovable, because we see in the jurisprudences there are so many courts decline buyback right is not under customary law. Ya, there is hukum adat tidak mengenal hak membeli kembali dalam tanah. So they decline it just like that. Yeah. So we have to limit this principle as applicable only to movable goods. The power to buy back the goods that have been sold is born from an agreement in which the seller is given the right to take back his goods that have been sold by returning the purchase price he has received along with all the costs that have been incurred to carry out the purchase and delivery, as well as the cost necessary for corrections and expenses that cause the goods sold increasing in value for that surplus amount. Right to buy back should not be promised for a period longer than 5 years. Okay, let's see. Hak membeli kembali bagian keempat. Kekuasaan untuk membeli kembali barang yang telah dijual diterbitkan dari suatu janji, di mana si penjual diberikan hak untuk mengambil kembali barang yang dijualnya. Take over ya. To reclaim ya, mengambil kembali barang dengan mengembalikan harga pembelian. Jadi kan this is just like cancellation ya. Asal dengan disertai penggantian yang disebutkan dalam pasal 1532. Nah, 1532 itu bicara macam-macam tuh. Tidak hanya mengembalikan harga pembelian, biaya yang diselenggarakan untuk pembelian dan penyerahan. Begitulah pula biaya-biaya untuk pembetulan. Dan biaya yang menyebabkan barangnya dijual bertambah. Oh, it's not easy ya. So if this, I don't know if this is a machine, for example, there is a cost to repair, you have to cover, right? But the value is not increasing, of course, because the machine is going down in value, right? So the last point, the seller shouldn't cover it. But it is limited, yeah. It cannot be more than 5 years. If the right is promised for a longer time, then that time is shortened to 5 years. If the seller neglects to file his claim to buy back within that stipulated grace period, then the buyer remains as the owner of the goods he has purchased. So the point is that limit is absolute. Yeah, I think there is a 1521. Jangka waktu yang ditentukan harus diartikan secara mutlak. Ia tak boleh diperpanjang oleh hakim. Dan apabila si penjual lalai memajukan tuntutannya untuk membeli kembali dalam tenggang waktu yang telah ditetapkan, maka tetaplah si pembeli sebagai pemilik barang. This is expiry kan daluarsa. When we agree on the time period, when it is lapsed, your right is gone. That is the daluarsa concept, right? And it is interpreted as absolute. So even though you go to the judge, you request for an extension, it won't happen. It is what it is. It is what has been agreed. So that's finito. That's an absolute period. In a sale and purchase with the right to buy back, it has been promised that the buyer during the promised period will not sell his goods to others, because at any time he can be requested to hand it back to the seller. If the sale is held without a promise that the price can be paid in installment. This is different now. Yeah, the second and the third one is reclaim right, but not the buyback right actually. This is another concept. So that's why it goes out of the sale and purchase provision. If the sale is held without a promise that the price can be paid in installments and the buyer does not pay the price, then as long as the goods are still in the hands of the buyer, the seller can demand that item as long as the claim is carried out within 30 days. So this is 1145. Ini hak reklame ya, hak reklame, hak reclaim. Jika penjualan telah dilakukan tunai, ya, maka si penjual bahkan mempunyai kekuasaan menuntut kembali barang-barangnya selama barang-barang ini masih berada di tangan si pembeli. Sedangkan ia dapat menghalangi dijualnya terus barang-barang itu asal saja penuntutan itu dilakukan dalam jangka waktu 30 hari setelah penyerahan. Ya, this is hak reklame, hak reclaim. Now, in here you can see in the 1445, yeah, it refers also to several articles in the Indonesian Commercial Code, yeah, 231, 233, 234, 236, and 237. This is, well, not many, I think, are going to do this, but of course, if you are going to do this, I think you have to file a claim to the court, yeah, to requesting this thing, to reclaim the goods. So you are the seller, you sell the thing, and the thing is possessed by the buyer, right? But the buyer hasn't paid.